The laughter began on the third paragraph. Mireille stood in the petitioner's position with her pages in her hands, and she listened to Lord. Fenwick read her words in the voice a person uses when they want a room to understand that the words are not worth taking seriously. The voice was precise in its cruelty, not loud, not theatrical. Simply tilted at an angle that transformed careful argument into absurdity, that made months of work sound like the complaint of someone who did not understand how things were done. The assembly laughed. Not all of them. Enough. She looked at the throne. King Emery sat with the specific, composed stillness of a man who had decided that what was happening did not require his intervention. He was looking at Fenwick. Then, for one moment, he looked at her. He looked away. She collected her pages. She did it methodically, in order, straightening each one against her palm before adding the next. Because her hands were entirely steady, and she intended them to remain so. The laughter continued while she collected them. It continued while she turned. It continued while she walked the full length of the court to the main doors, which she opened herself, which closed behind her with the specific, weighted sound of something that had made up its mind. She stood in the corridor. The laughter continued on the other side of the doors, muffled now, reduced by the thickness of the wood to something she could hear, but not quite feel. She stood with her pages against her chest and breathed once, twice, and then she began to walk. She did not look back. Which country are you listening from? Please comment below. I'd love to know how far this story reaches. The room she had rented near the court archives was precisely large enough for a desk, a cot, a small stove, and the accumulated documentation of 11 months of research. She had arrived with 2 travel cases and had gradually filled every available surface with the specific, organized density of a scholar who understood that her materials were her tools and treated them accordingly. The legal library had been her second home for those 11 months. She arrived when it opened and left when it closed, and in between she did the work that the petition required, not the work of assembling an argument, which was the part she could do anywhere, but the work of finding the precedents, the historical records, the administrative decisions buried in decades of legal archive that constituted the evidentiary foundation, without which the argument would be persuasive rather than irrefutable. She had learned, early in her legal education, that persuasion was insufficient. Persuasion could be resisted by a person who wanted to resist it. She needed something stronger than persuasion. The archive was where Ran lived. Ran was 63 years old and had worked in the court archive for 38 of them, which meant she had outlasted 11 senior archivists and 4 changes of administration and 1 significant flood that destroyed a third of the Western holdings and required a reconstruction effort she had personally overseen. She was small and precise and had the specific quality of attention that develops in people who spend their professional lives in proximity to old documents, a habit of thoroughness, an instinct for what a record was actually saying rather than what it appeared to say, a complete intolerance for careless citation. She had been providing Mireille with access to restricted holdings for 6 months. Not illegally. Ran had spent 38 years learning the precise architecture of the archive's access regulations, which meant she also knew the precise architecture of their exceptions, and she had been navigating Mireille through those exceptions with the methodical care of someone who understood that the goal was the research, and the research required the documents, and the documents required someone who knew the building as well as Ran did. She had never explained why she was helping. Mireille had never asked. They had worked together in the comfortable, productive silence of 2 people who understood the same things about what the work was for. The petition had taken 11 months to write. Not continuously. There were weeks when she could not advance it, when the evidence she needed was in a holding she had not yet reached, or when the argument required a structural revision that meant returning to the beginning and rebuilding from a different angle. She revised it 14 times. She was not certain, at the end of the 14th revision, that it was finished. She was certain that it was as complete as she could make it with the materials and the time available, and that it was more complete than any similar document she had encountered in the archive's records. She submitted it on a Tuesday morning through the official petition office, a small room adjacent to the court's administrative wing, staffed by 2 clerks who received her submission with the practiced indifference of people who had learned to process without engaging. She signed the receipt. She took her copy of the submission acknowledgement. She walked back to her rented room and sat at her desk and felt the specific, clean satisfaction of having done a thing correctly. She had not told herself it would succeed. She had told herself it was accurate and complete, and that she had done everything within her power to make it so. The outcome was not within her power. She had learned, at some cost, to respect that distinction. The summons arrived 3 weeks later, a formal notification that her petition would receive formal consideration at the next full court assembly. She read it twice. She pressed it flat on her desk. She reviewed her pages one more time, which was the 14th and a half revision. A half revision consisting entirely of reading rather than changing, because there was nothing left to change, and she knew it. She ironed her best dress the evening before. She organized her pages into their final order, and placed them in the leather folder she had purchased specifically for their presentation, a small, deliberate act of respect for the work. She reviewed her planned oral remarks, which were brief because she had always believed that a legal document should argue for itself, and that the petitioner's role was to present rather than to perform. She slept adequately. She rose at the 5th bell. She was entirely ready. She stood in the petitioner's position at the full court assembly the following morning with her pages in their leather folder, and she looked at the assembled court, and she thought, 11 months. She thought, 14 revisions. She thought, every precedent verified, every citation confirmed, every argument built from its foundation. She thought, looking at Lord Fenwick as he rose from his seat with the expression of a man reaching for something he found amusing. I have been more careful than any of you deserved. She was right. It did not help. She had a name for it, privately, in the precise interior language she used when she needed to think about something accurately rather than comfortably. She called it crystallization. Not because the word was poetic. She was not particularly interested in poetry as a functional category, but because it was accurate. What happened when she wrote with full attention and full honesty was a process of progressive clarification, each word settling into a position of ethical exactness relative to the words around it. The way crystals form when the conditions are precisely right, not imposed, not forced, but arrived at through the internal logic of the material itself. The result was a text that had achieved, at the molecular level of its argument, a completeness that made contradiction structurally unavailable rather than merely difficult. This was the gift. She had understood its mechanism for years. She had understood it since she was 15 years old, and a landlord's solicitor had withdrawn an eviction claim he had been prosecuting with professional confidence for 3 months, unable to explain why he had done so. Unable to find anything in his notes that justified the withdrawal, simply finding himself unable to continue. The solicitor's name had been Garrett. He was a competent man, not a good man, but a competent one. The kind whose professional performance was entirely reliable when the task he was performing had a functioning internal logic. The eviction had had a functioning internal logic until Mireille had written 6 pages of careful argument on behalf of her aunt, demonstrating with documented precision why it was legally invalid and morally unjustifiable. She had slid those pages across the table in the landlord's office, and Garrett had read them, and the internal logic of the eviction had ceased to function. She had been 15. She had watched him read her pages with the clinical attention she brought to legal proceedings even then, noting the moment his expression changed, not softening, not becoming sympathetic, becoming unable. Becoming a face that was trying to perform a cognitive function, and discovering the path to it was gone. The eviction had not proceeded. No explanation was filed. Garrett had simply withdrawn the claim. Mireille had walked home from the landlord's office understanding two things with complete clarity. The first was that she had a gift unlike anything she had encountered in her reading or her experience. The second was that the gift required her to be correct, not merely careful, not merely thorough, but genuinely, honestly, verifiably right, because the crystallization only occurred when the argument was fully supported by honest evidence and genuine moral conviction. She had tested this carefully in the years that followed. Every test had confirmed the same requirement. The gift was not a shortcut. It was an amplifier. It made true things irresistible. It could not make false things true, and it could not make careless things careful. And it could not make arguments she did not fully believe into arguments that convinced anyone. It required her to do the work first. This was why she revised obsessively. This was why she spent 11 months on a petition that a less careful writer would have produced in 3. The gift only activated when the work beneath it was sound, which meant the work beneath it had to be sound. She had never found this to be a burden. She had found it in the specific way of constraints that turn out to be principles, to be clarifying. She had understood all of this for years. She had not told anyone with authority. She had told Ren obliquely, in the careful way of someone testing whether information will be received safely, and Ren had received it with the thorough, unsurprised attention of someone who had been processing unusual things in documents for 38 years and had long since developed a working relationship with the extraordinary. Ren had said, "Then you had better write it correctly." Mireille had said, "That is always my intention." Ren had said, "Yes, but now I understand why." She sat at the cottage table 3 days after the humiliation. Outside, the border territory was conducting its ordinary early winter business, gray sky, bare trees, the sound of wind making itself known in the gaps of the cottage's old construction. The cottage was cold in the way of buildings that have not been occupied for some time and are slowly, reluctantly warming to a new presence. She had one candle. She had the paper she had purchased before leaving the capital with the focused practicality of someone whose first response to crisis was to assess what materials the next phase of work would require. She had a fresh pen and the particular quality of clarity that sometimes follows devastation, the specific, cold, wide-open clarity of someone who has had something taken from them and has decided that the taking was not the end of the story. She thought about what the petition had been, a request submitted through official channels, following every requirement, asking the people with authority to consider extending some of that authority's protection to people it currently excluded. She thought about what she was going to write now, not a request, a framework, a complete legal architecture, built from documented precedent and moral logic and the full weight of her gift, that would move through the kingdom's legal system not by asking for permission, but by making denial structurally impossible. The Omega Charter. She had been building it in pieces for years. Each document she had written, each small local case, each careful argument that had produced an inexplicable judicial outcome had been, in retrospect, a component of something larger that she had not yet assembled. She was going to assemble it now. She put pen to paper. The first word went down in the clean, deliberate hand she used for documents that mattered. The candle flame steadied. The cottage settled around her. Outside, wind moved through the bare trees with the sound of something that had been waiting a long time to be released. Her mother's name was Celeste, and she had been the best teacher in the mid-territory school for 14 years before the regulation took effect. This was not Mireille's assessment. It was the documented assessment of the school's administration, recorded in the annual performance reviews that Celeste had preserved with the careful, unsentimental precision of a woman who understood that a written record was the only form of evidence that survived memory's tendency toward revision. 14 years of reviews, all of them using words like exceptional and irreplaceable and a credit to this institution. Celeste had kept them in a leather folder, not unlike the one Mireille would later purchase for her petition pages. The resemblance was not accidental. The regulation had been passed on a Thursday in the third month of the year, by a legislative body that contained no Omega representatives and had not sought Omega consultation. In a session that lasted 40 minutes and produced, among other things, a provision requiring all educators in Crown-affiliated schools to hold a formal teaching certification issued by the Royal Education Office. The provision was not unreasonable on its face. The Royal Education Office's certification process had, until that year, been open to all qualified applicants regardless of designation. In the same session, without announcement or explanation, the eligibility requirements for the certification had been amended to exclude Omega-designated applicants, pending a review of designation-specific competency frameworks. The review had no scheduled completion date. Celeste received her notice of dismissal on a Monday morning. It was 4 paragraphs long. It cited the regulation by its official number. It offered no appeal mechanism, because the regulation provided none. It thanked her for her 14 years of exceptional service. Mireille was 11 years old. She sat across the kitchen table from her mother and watched her read the notice and understood, with the specific, terrible clarity of a child who has been given an adult's precision of mind without the adult's practiced capacity for absorbing injustice, that something was being done to her family that was wrong, and was being done anyway because it was written down, and the words that were written down were the ones with authority. Her mother read the notice twice. She set it down on the table with the careful, deliberate movement of someone managing her own reaction in the presence of her child. She looked at Mireille. She said, in the quiet voice she used when she was saying something she wanted remembered, "The words that hurt you most are always the ones written down, because those are the ones that last." Mireille had understood this at 11 in the way her mother intended it, as a statement about the permanence of institutional harm, the way written regulations outlasted the moments that produced them and continued to function long after the people who wrote them had moved on to other concerns. She had understood it as something to grieve. She had also understood it as something else, something her mother had not intended and might not have recognized in the statement if Mireille had named it. She had understood it as a direction. If written words had the most authority, then written words were where the contest had to be conducted. If the regulation that ended her mother's career existed because someone had written it, then the protection that would have prevented it had failed to exist because no one had written it yet. The harm was written. The remedy needed to be written. The question was not whether it could be done. Language was not the property of any single designation. Ink was not reserved for the powerful. Paper was not more receptive to one hand than another. The question was only who was going to write it. She had started that year, 11 years old, with the school legal textbook she had borrowed from her mother's shelves and a notebook she kept under her mattress. She had begun learning the architecture of the law the way other children learned instruments, slowly, with the long-term orientation of someone who understands they are building towards something they cannot yet fully see. She had continued through her adolescence and into her adulthood, formally and informally, through every educational opportunity available to an Omega in a system that provided fewer than it should, supplementing every gap with the archive and her own reading and the specific, self-directed discipline of someone who knows that no one is coming to teach them what they most need to know. Her mother had found other work. She had never taught again. The review had not concluded. The certification had not opened. The regulation had persisted long past any administrative justification for it. She had managed. She was a woman of considerable capability, and she had applied that capability to whatever was available. And she had been fine in the practical sense of the word. And the practical sense of the word was not the only sense that mattered. Mireille sat in the cold cottage with the charter's first page in front of her and thought about her mother's teaching certification and the 4 paragraphs of the dismissal notice and the 14 years of exceptional reviews preserved in a leather folder. She thought about the legislative session that had lasted 40 minutes and had restructured her family's life without consultation or appeal. She thought about what she was writing and what it would do when it moved through the kingdom's legal system, and what it would make impossible for the next woman who received a 4-paragraph notice on a Monday morning. 3 weeks later, a knock at the cottage door broke the silence of her work. She set down her pen and opened it to find Ren, breathing hard from the road, her archive clerk's coat dusted with travel, her eyes carrying the specific brightness of someone delivering information they have been carrying at speed. The first document had reached the regional court, Ren said. The judge had issued an unprecedented written statement. He could not rule against it. He had tried, she said, in the careful voice of someone reporting something they want to get exactly right. He had tried 3 times and he could not. Mireille said nothing for a moment. She looked at Ren. She looked at the road behind her, empty and winter bare. She looked at the pages on her table and the candle burning beside them and the charter in its careful, progressive construction. Word is spreading, Ren said. They do not yet know who wrote it. Mireille stepped back from the door. Come in, she said. There is more to write. The word unprecedented appeared in 17 separate judicial documents in the same week. This was the detail that caught the attention of the Royal Legal Office's senior analyst, a methodical man named Croft who had spent 20 years tracking patterns in judicial language and had never, in those 20 years, seen a single word appear with that frequency and that consistency across unconnected jurisdictions in a 7-day period. He compiled the occurrences into a report with the focused attention of someone who understands that a pattern this specific is not coincidental and that its source is more important than its surface. The first occurrence had come from the regional court in the Eastern Territory, Judge Aldrich Sorn, a man with 30 years on the bench and the reputation of someone who had never issued a ruling he could not justify in full procedural detail. His written statement was 4 pages long and was, by the standards of judicial documentation, extraordinary. It described a document submitted as supporting evidence in an Omega housing case, a document he had not been able to rule against on any of his prepared grounds. He had prepared 7 grounds. He had attempted each one. Each attempt had produced the same result, a complete inability to complete the reasoning chain. Not because the chain was interrupted, but because each link he assembled led, with an inevitability he could not circumvent, back to the document's own premises. He had written, in the careful language of a judge filing something he understood would be reviewed by people who would find it difficult to credit. I do not have adequate professional vocabulary to describe what I encountered in this document. I can state with certainty that ruling against it was not available to me as a judicial option at the time of deliberation, and that I believe this to reflect the document's exceptional quality rather than any failure of my own processes. Croft read this statement twice. He filed it. He moved to the second occurrence. In the Southern Territory, a senior enforcement official named Dunmore had attempted to complete a housing eviction that directly contradicted one of the charter's provisions, the provision establishing that Omega-designated residents could not be evicted without a formal independent review. The provision was not yet law. The charter had not yet passed through the kingdom's formal legislative process. Dunmore had the existing law on his side, an assigned enforcement order in his hand, and a constable beside him, and 4 years of professional experience completing enforcement actions without incident. He had not been able to complete it. He had filed a report with his superior the following morning that described the experience in the careful, slightly desperate language of a professional confronting something his training had not equipped him for. He had arrived at the property. He had read the enforcement order. He had begun the formal enforcement protocol. At the point where the protocol required him to formally notify the resident that the eviction was being carried out under legal authority, he had experienced what he described as a complete failure of the action's internal logic, a sensation he compared with the apologetic hedging of someone aware that this comparison was not going to improve his credibility, to attempting to argue that 2 and 2 made 5. He had been unable to locate the argument. The enforcement order was still in his hand. The action was still technically valid under existing law. He had been unable to proceed. He had documented it, filed the report, and requested guidance. His superior had no guidance to offer. The superior had forwarded the report to the Royal Legal Office, where it had arrived on Croft's desk alongside 11 others. The jury case was the most documented, a formal Omega rights proceeding in the Northern Circuit. The kind of case that typically required 3 days of deliberation and produced a split decision. The legal questions were complex, the precedents were contested. The political pressures on the jury were real and well understood by every practitioner familiar with that circuit. The charter had been submitted as supporting evidence by the Omega petitioner's representative. The jury had received it. The jury had returned a unanimous verdict in favor without deliberation, without entering the deliberation room. The foreman had asked to approach the bench and had said, in a voice that the court reporter had described in her notes as bewildered but certain, "We have read the document. We are in agreement. We do not require additional time." The presiding judge had asked if the jury had understood the complexity of the questions before it. The foreman had said, the document made the questions simple. She had said it as if this were a sufficient explanation. Croft's report ran to 31 pages. He had cross-referenced all 17 judicial documents, identified the common element, a single document or documents drawn from a common source, submitted in each case as supporting evidence, and traced the submission records through the regional court's administrative systems with the methodical patience of someone who understood that the answer was in the paperwork if the paperwork was read carefully enough. The common element resolved to a name on 3 of the submission records. The other 14 had not yet been fully traced. The name on the 3 was enough. He brought the report to the king's senior legal advisor on a Thursday afternoon and presented it, with the professional equanimity of a man who has learned that the most important thing about delivering alarming information is to deliver it accurately. The advisor read it in silence. He read it again. He took it to Emery's that evening without scheduling an appointment, which was the specific protocol he used when something could not wait for the morning. Emery's read the report in his private study with the focused attention of a man who reads everything he is given as if it might be important, which was one of the better habits of his kingship. He read to the bottom. He read the name at the bottom of page 31. He looked up at his advisor. He said nothing for a long moment. His advisor said, "The submission records identify her as the author. The document producing these outcomes appears to be a comprehensive legal framework she has titled the Omega Charter." Emery's looked back at the report. He looked at the name. He thought about the court assembly and the leather folder and the pages collected methodically while the laughter continued. He thought about the moment he had looked at her and looked away. He said, "Find her." His advisor brought him a copy of the charter the following morning. It was not the original. The original was presumably still in the border cottage where Croft's trace had placed her. And Emery's had not yet determined what he intended to do about that, but a copy made from the version submitted to the Eastern Territories Regional Court, transcribed by a court clerk with adequate handwriting and no apparent understanding of what he was copying. The transcription was clean. The arguments were intact. Emery sat with it in his private study after the morning session. He had cleared the afternoon deliberately, telling his scheduling advisor that he had documents requiring extended review, which was true in the specific and unusual sense that the documents in question were going to require more of him than extended review typically did. He read it alone. This was a choice he made consciously. In the moment of sitting down, the recognition that a document that had produced the judicial outcomes Croft had documented was not something to receive through an advisor's summary or a clerk's extraction. It was something to encounter directly, which meant reading it himself, from the beginning, in the order it was written, without the mediation of someone else's understanding of what it contained. He began. The first section established the legal and historical foundation, a meticulous reconstruction of Omega designation law across 400 years of the kingdom's legislative record, tracing the specific points at which the legal protections available to Omega-designated citizens had diverged from those available to other designations, documenting each divergence with the precision of someone who had read every primary source and verified every citation. He had employed legal scholars who could not have done this more thoroughly. He kept reading. The second section presented the evidentiary case, 17 documented categories of harm produced by the current legal framework, each category supported by specific cases, each case cited with full documentation. Welcome back to the Alpha King Rain channel. Today I'm bringing you a brand new and incredibly captivating story that will surely enthrall you if you listen to the whole video. The story is entirely fictional. The video is created using AI, and it's designed to provide value, entertainment, and positive education for viewers aged 13 and up. Now, let's dive into today's story. The aggregate producing a picture of systemic failure so complete and so precisely evidenced that he found himself doing something he did not typically do when reading legal documents. He found himself being affected by it. Not persuaded. Persuasion was a cognitive event. Something that happened in the part of the mind that assessed arguments. This was something that happened below that level. Something that was making the floor of his professional detachment less stable than it had been when he sat down. He kept reading. The third section proposed the remedy, the Charter's specific provisions, each one introduced with the logical necessity of the previous sections fully established, each one constructed so that its relationship to the documented harm was not arguable but demonstrable. He prepared, at several points, to find the weakness, the point at which the argument outran its evidence. The provision that required a leap the evidence did not support. He did not find it. Each time he assembled the beginning of a counter-argument. The document had already addressed the counter-argument's premise, had already provided the documentation that made it unavailable, had already closed the logical path he was trying to walk. Then the gift activated. He felt it not as compulsion in the way he understood compulsion, not as force, not as pressure, not as anything that suggested his will was being overridden. He felt it as a quality of clarity that he had not experienced before in his reading of legal texts. The specific sensation of an argument achieving a completeness that made the space between its premises and its conclusions not a gap to be bridged by persuasion, but a single continuous surface, on which there was no room for contradiction to stand. He sat with it for a moment, examining the sensation with the analytical attention he applied to unusual experiences, and understood that what he was feeling was not the document compelling him toward a conclusion, but the document making the ethical truth of its conclusion so fully visible that choosing against it would require a deliberate act of moral corruption he could not locate in himself. He set the charter down. He sat for a long time. He thought about the court assembly. He ran through it with the specific, surgical honesty of someone who has decided to stop managing his own discomfort and look at a thing directly. Fenwick rising. The exaggerated voice. The particular quality of the laughter, not cruel laughter, which would have been easier to condemn, but the lazy laughter of people who found something easy to dismiss and were enjoying the ease of dismissing it. His own face, arranged in the composed expression of a king presiding over a proceeding he had decided did not require his full attention. The pages being collected, every one of them in order, with the steady hands of a woman who had spent 11 months on those pages and was not going to allow the people who were laughing to disarrange them. His own eyes meeting hers. The moment of contact. The moment he looked away. He picked up his pen. He looked at the charter on the desk beside him. He looked at his senior advisor's door. He said, to the empty room, I was wrong. It was the first time he had said it aloud. It was not adequate. He understood it was not adequate. But it was the beginning of something that needed to begin, and beginnings, in his experience, required a first word. He opened his study door. He told his advisor, send a rider north. I need her location confirmed. Then come back. I have something to tell you about what I have been doing with this afternoon. The decision to ride himself was not approved of by anyone he told. His senior legal advisor said, send a formal delegation, which carries the appropriate institutional weight and does not require the king to spend 3 days on a northern road in early winter. His court secretary said, there are 14 pending matters that require your signature this week alone. His senior guard captain said nothing, but produced an expression that communicated his position with complete efficiency. Emery's overrode all 3 without significant drama and with the specific, final quality of a decision that has been made rather than deliberated. He rode out the following morning with his legal advisor, 2 guards, and the copy of the charter in his saddlebag, which he had read twice more since the afternoon in his study, and which had produced, on both subsequent readings, the same quality of crystalline clarity that he was beginning to understand was not going to diminish with familiarity. He had not sent a message ahead. He had considered it and decided against it, with the honest self-awareness of a man who understood that the decision not to announce himself was not courtesy but calculation. A message would give her the opportunity to decline, and declining was what she would do. And he was not yet certain he had the standing to argue against the decline. Arriving without announcement at least required her to make the refusal in person, which was harder, and which was, he acknowledged privately, a moderately manipulative rationale. He rode north with it anyway because the alternative was not going at all, and not going was no longer available to him as a genuine option. The border territory received them on the 3rd day with the indifferent gray beauty of a landscape that had been doing its own thing for a very long time and did not adjust for visitors. The cottage was where Crofts Trace had placed it, small stone, set back from the road behind a stand of bare trees, smoke rising from the chimney in the thin, decisive line of a fire that had been properly built and was doing its job. He left the guards and his advisor at the road. He walked the path to the cottage door alone, which his guard captain would have objected to if he had been consulted. He had not consulted him. He knocked. A pause, the specific pause of someone who has heard a knock and is deciding something before responding. Then footsteps. The door opened. She looked at him without surprise. This was the first thing he registered, that the absence of surprise was complete and genuine. Not managed into composure, but simply not present, because she had apparently anticipated something in this direction and had prepared herself for it, and was therefore entirely ready when it arrived. She looked at him with the direct, unsparing attention he had seen across the court assembly and had not, in that context, actually seen because he had not been paying the right kind of attention. He was paying it now. He saw, looking at her for the first time as a person rather than a procedural element. A woman of perhaps 30 with the specific quality of someone who has been doing difficult, solitary work for an extended period, a focused alertness in her eyes, a stillness in her posture that was not tension but concentration, the kind that becomes habitual in people who spend most of their time with arguments that require the full engagement of their minds. He said, "May I come in?" She said, "That depends on why you came." He said, "I read the charter." A pause. It contained several things: her assessment of that statement, her assessment of him making it, her decision about what the statement's significance was and whether it was sufficient. She said, "And?" He said, with the honesty he had been practicing since the afternoon in his study, "I could not find anything in it that was wrong." She looked at him for a moment longer. She stepped back from the door. He entered. The cottage was organized exactly as he had imagined from the road, entirely around the work. The desk held the charter in progress. The current pages stacked with the precision of a writer who thinks of her manuscript as a living document requiring careful management. Additional papers were arranged in labeled groupings along the window ledge. 2 candles, a pot of tea going cold, a single chair at the desk, and a second near the small hearth. Positioned with the practical geometry of someone who had not expected company, but kept a second chair because furniture, in her world, served functional rather than social purposes. On the table beside the charter, held flat by a smooth stone used as a paperweight, was a second document. Its title was visible from where he stood near the door. He read it without moving closer. He read it once, and then he read it again. A formal account of the events of the 23rd day of the court assembly, with supporting documentation of institutional complicity. He looked at her. She was watching him read the title with the calm, assessing attention of someone observing a reaction and noting it for accuracy. He said nothing. She said nothing. The fire made its small, steady sound in the hearth. Outside, the winter wind moved through the bare trees with the indifferent persistence of something that had been here long before either of them and would be here long after. He said finally, "How long have you been working on that one?" She said, "Since the morning after the assembly. It is almost complete." They sat across from each other at the cottage table with the charter between them and the second document to one side, and the fire making its ordinary sounds in the hearth, and neither of them performing any quality of ease they did not actually have. He asked about the second document first. She told him it was a complete formal record of the court assembly proceedings, annotated with documentary evidence of the institutional pattern the assembly represented, not that particular assembly only, but the pattern of which it was an instance, documented across 12 years of petition records showing how Omega formal submissions had been received, handled, and dismissed by the court's administrative apparatus. She told him it was not for publication. She paused. She said, "Not yet." He heard both parts of that statement. He filed them both accurately. He asked about the charter. Not a general question, specific ones. The questions of a man who had read something carefully and wanted to understand it more completely than reading alone had allowed. He asked about the 4th provision, the one governing Omega representation on legislative bodies, and why she had structured the enforcement mechanism the way she had rather than the more conventional approach used in similar provisions in the Eastern Territories local law. She answered with the precision of someone who knows her own work from every angle, the alternative approaches she had considered, the specific weaknesses in the conventional mechanism, the way her chosen structure addressed those weaknesses while remaining within the existing legal framework rather than requiring the framework's replacement. He listened with the focused attention of a man who was genuinely learning rather than performing engagement. They went through 3 provisions. The conversation shifted, not all at once, but in the gradual way of conversations between two precise minds who have stopped managing their interaction and started conducting it. The formal distance between a king and a petitioner was still present, technically, but it had become a technical rather than an actual quality of the exchange, still there on the surface but no longer determining what moved below it. He said, "I want to apologize for what happened in the court." She was quiet, not the quiet of someone managing a response, but the quiet of someone who has decided to let something arrive fully before they respond to it. He continued. He said it had been wrong. He said the specific wrong of it was not only Fenwick's performance. Fenwick had done what Fenwick did, which was a problem but a comprehensible one, but his own decision not to stop it. He named the calculation he had made. The assessment that the political cost of taking her petition seriously in a room that had decided not to was higher than the cost of allowing what was happening to continue. He named it without softening. He said, that calculation was wrong. Not merely incorrect in its outcomes, wrong in its structure. I treated a question of basic respect as a question of political expenditure. She listened to all of it. When he finished, the silence had the quality of something that had been fully received rather than politely absorbed. She said, "I appreciate the apology." She paused. She said, "I want you to understand that what I need from you is not the apology." He said, "I know." She said, "What I need from you is the charter signed into law. Every provision, enforceable, with an independent review mechanism to prevent quiet repeal after the immediate political attention moves elsewhere." He said, "I know." He said, "I am working on understanding what that means in practice." She said, with the directness that characterized everything she said that mattered, "So am I. The legal implementation is more complex than the writing. I have been working on a supplementary framework for the implementation sequence." He said, "I would like to see it." She looked at him for a moment, assessing, with the specific attention she gave to all information she needed to evaluate accurately. She reached into the stack of papers along the window ledge and produced 6 pages, which she placed on the table between them. They worked through it for an hour. He asked questions. She answered them. She asked, at one point, whether the council's legal team had reviewed the charter's conflict with the existing educational certification regulation. And he said they had not yet fully addressed that specific conflict. And she said she had a documented analysis of the conflict and its resolution in her materials. And she produced it, and it was exactly what she had said it was. When they finished, he stood to leave. He looked at the cottage, the cold, the single candle on the desk, the organized austerity of the working space. He said nothing about any of it. He walked to the door. He turned back once. He said, "The work in this room is the most important legal writing currently being produced in this kingdom. I want you to know I understand that." She said, "That has always been true. It would have been useful for you to understand it earlier." He said, "Yes." He said it without defense, without the instinct to qualify. Simply as a confirmation of an accurate statement about a fact he intended to carry rather than resolve. He left. He walked back to the road where his advisor and guards were waiting. He said quietly to his advisor, "Send firewood to this cottage. Enough for 2 months. Do not attach my name." His advisor looked at him with the expression of a man who has worked for this particular king for 11 years and has just encountered something new. He said nothing further. He mounted his horse. He turned south toward the capital. The palace was quiet at the second bell of the night, and Emrys was not sleeping. This was not unusual in the general sense. He slept adequately on most nights, with the disciplined regularity of a man who understood sleep as a performance requirement and had organized his habits accordingly. But there were nights when the mind's accounting could not be deferred to morning, when the day's accumulation demanded to be processed before it could be set aside. And this was one of those nights in the specific and more demanding way of a night, when the accounting concerned not the day's events but something older and more fundamental that he had been avoiding with the practiced efficiency of a man who had elevated avoidance into a kind of administrative skill. He sat at his writing desk with no documents open, which was unusual. He sat with his hands flat on the desk surface and the candle burning and the palace quiet around him. And he did what he had been avoiding for the 3 days since he returned from the cottage. He reviewed the court assembly without the management. Not the institutional review he had been conducting, the assessment of what procedures had failed, what oversight mechanisms had been insufficient, what administrative corrections were required. The personal review, the one that did not have a procedural framework and did not produce an action item and did not resolve into a recommendation for the council. The petition had arrived through official channels. Every requirement met. 11 months of work compressed into pages that, he now understood, represented the most rigorous legal scholarship currently being produced anywhere in the kingdom. It had been submitted correctly. It had been processed correctly by the administrative system. It had been assigned to the Assembly's agenda correctly. Every procedural mechanism had functioned as intended. And then it had arrived at the Assembly, and the assembly had laughed. He thought about why he had not stopped it. Not the explanation he had given himself in the first days, the management explanation. The one about political capital and the strategic inadvisability of elevating a minor administrative matter into a political incident. He had already named that explanation for what it was in the cottage to her face, which had required something of him and had produced something in him that he was still integrating. He thought about it again now in the privacy of the second bell, with no face across the table to be honest for, and therefore only himself. He had not stopped it, because stopping it would have required him to publicly disagree with his own senior counsel in real time, in front of the full assembly, over a document he had not read and a petitioner he had assessed. In the half-second of attention he had given her before the session began, as someone unlikely to require his direct intervention. He had not read the petition before the assembly. He had received a 3-line summary from his scheduling advisor and had accepted the summary as sufficient. He had walked into the assembly knowing 3 lines about a document that was, as he now understood, extraordinarily important, and had sat on his throne with that 3-line knowledge and had decided, when the laughter began, that the 3 lines did not constitute sufficient basis for intervention. This was the root of it, not a failure of courage, though that had also been present, a failure of attention. He had not thought she was worth his attention, and had not given it. And in the absence of his attention he had had nothing, no basis, no knowledge, no context in which to recognize what he was allowing to happen. He thought about the charter. He thought about the 47 pages that 11 months of full attention had produced. He thought about the afternoon in his study when the gift had activated, the quality of clarity, the specific sensation of an argument so completely honest that refutation became structurally impossible, and he thought about what it meant that this was what he had dismissed with 3 lines and a failure to look. He picked up his pen. He wrote 2 things. The first was formal, a letter to Mireille indicating royal review of the charter and requesting a formal consultation in the capital, phrased as a request rather than a summons because he had determined in the cottage that summons was not the register that this situation warranted. The second was private, a note to himself in the shorthand he had developed in adolescence for thoughts he needed to hold rather than act on, a place where things could be true without immediately becoming decisions. He wrote, "She was the most careful person in that room. I was not." He looked at the sentence for a moment. It was accurate. It was not comfortable. He was becoming more tolerant of accurate discomfort than he had previously been, which he understood was part of what the past weeks had been doing to him, and which he did not intend to reverse. He sealed the formal letter. He folded the private note and placed it in the drawer where such notes lived. He was reaching to extinguish the candle when the sound reached him, footsteps in the outer corridor, rapid and purposeful. His senior advisor knocked once, and entered with the expression of someone carrying information that had chosen an inconvenient hour. "Lord Fenwick," he said, "has called a private meeting of the Senior Court Council. The charter is on the agenda. The meeting was called without your knowledge or authorization. It concluded an hour ago." Emery's was very still. He said, "What was decided?" His advisor said, "A formal legal strategy. They are preparing a high court challenge to the charter's validity." She had requested the legal library as the meeting location, and he had agreed without argument. This was noted by his senior advisor, who had been present when the request arrived, and who had observed the king's response to it with the particular attention of someone tracking a development they find significant. The palace had formal consultation chambers, rooms designed specifically for the kind of meeting this was, equipped with the appropriate furniture and the appropriate symbolic weight of institutional settings. The legal library was none of those things. It was a working space, a long room on the palace's eastern wing-lined floor, to ceiling with the accumulated legal record of 400 years, smelling of old paper and the specific, concentrated quality of places where serious thinking had been done for a very long time. She had chosen it because it was honest. He understood this when he arrived and found her already there, standing at the long central table with the charter's implementation framework spread before her. Not waiting for him, but working, already in the middle of the thing they were meeting to discuss, which was simply her operating at her characteristic pace and in her characteristic mode, and not adjusting either for his arrival. He sat across from her. He did not announce himself. He simply sat, and she finished the sentence she was writing, and then she looked up. They worked through the charter's implementation for 2 hours. Not him reviewing her work. That framing had dissolved somewhere in the cottage. In the hour they had spent on the supplementary framework with the specific equality of two people who are both trying to solve a problem and have collectively more of what the problem requires than either has separately. This was more of that. He knew the kingdom's legal architecture from the inside, the specific resistance points, the places where existing law would require explicit supersession rather than simple amendment, the sequence in which the provisions needed to move through the legislative process to create the most durable structure. She knew the charter from the inside, every premise, every evidentiary foundation, every point at which the argument's logic would be tested and what the test would look like. Together they were building something more complete than either had been building alone. He told her she was extraordinary to work with. He said it in the plain, direct way he had been practicing, without ornamentation, without the hedging of a compliment offered as strategy, simply as an accurate statement about something he had observed. She received it with the careful attention she gave to all information she needed to assess honestly. She neither deflected nor accepted it without examination. She considered it for a moment and then said, "You are more useful than I expected." He said, "I am choosing to take that as a significant compliment given the baseline." Something moved in her expression that was not quite a smile and was not a smile. He noted it and said nothing further, understanding that it was the kind of thing that got smaller if you pointed at it. He asked why she had come back to the capital for this. She said, "Because the implementation work requires access to the archive, and the archive is here. And the work is more important than my preference for the cottage." He asked about the cottage. She said it was adequate for writing. She said adequate with the specific quality of someone for whom adequate was a high standard rather than a low one, the quality of a person who had organized their life around the work and considered everything else secondary to whether it served that purpose. He asked about her family. She told him about her mother, briefly. In the economy of someone who has refined a complicated story to its essential facts through the long practice of carrying it, the teaching certification, the dismissal notice, the 14 years of exceptional reviews that had not been sufficient protection against 4 paragraphs written by a legislative body that had not thought to ask whether protection was required. He listened. He did not offer the conventional responses, did not reach for the reassuring reframe or the expression of sympathy that converts another person's difficult history into a moment of one's own generosity. He simply listened with the complete attention of someone who has decided that listening is the thing required and is doing only that. When she finished, he was quiet for a moment. Then he said, "The educational certification provision in the charter, the one requiring the Royal Education Office to open certification to all qualified applicants regardless of designation. Is your mother still teaching?" She said no. She found other work. She managed. He said, "The provision has a retroactive assessment clause. Educators dismissed under the regulation since its passage are eligible for reinstatement review." She looked at him. She said, "I know. I wrote it." He said, "I know you did." They looked at each other across the charter's pages in the amber light of the library's late afternoon. And the sentence carried everything it was carrying, and neither of them elaborated on it. They finished the session at the 6th bell. He walked with her to the library's main door, the long corridor of archived law, the accumulated written record. The evening light coming through the high windows at the specific angle of early winter that made old paper look like it was lit from within. At the door, neither of them moved immediately to leave. He said, "Same time tomorrow. There are 4 provisions we did not reach." She said, "Yes." They went their separate directions through the palace. He walked back toward his wing and thought about retroactive assessment clauses and the specific, deliberate way she had written one into the provision that most directly addressed her own family's harm, and what that told him about the kind of person who writes laws from the inside of the wound they are trying to close. Lord Fenwick's legal strategy had taken 11 days to construct. This was not because he was slow. He was not slow, had never been slow, had built 30 years of political influence on the specific quality of a mind that moved quickly through complex situations and identified the available leverage points before anyone else had finished reading the situation. It had taken 11 days because the situation was genuinely complex. Because the target of the strategy was not a simple petitioner with an administrative complaint, but a woman whose document had produced unprecedented judicial outcomes across 3 jurisdictions and who had just spent 2 weeks in daily consultation with the king. And because the strategy needed to be airtight in a way that most of his strategies did not. Precisely because the person he was deploying it against had a documented habit of making non-airtight arguments collapse. The High Court challenge had 3 components. The first argued that the charter had been authored by an unregistered legal practitioner. In the kingdom's legal framework, documents submitted as binding legal frameworks required their authors to hold formal registration with the Royal Legal Office. Mireille held no such registration. She had never applied for it, because the registration process had, since its establishment 40 years prior, been formally open to all designations and informally accessible only to those with the institutional connections and financial resources that Omega-designated applicants rarely possessed. The argument was technically accurate. It was also the kind of accurate that requires significant additional context to be honest, which Fenwick understood and had decided was not his problem. The second component argued that the charter's documented effect on judicial proceedings constituted improper interference with the legal process. The 17 judicial documents Croft had compiled, which had entered the formal record through the Royal Legal Office's standard documentation procedures, described outcomes so unprecedented that Fenwick's legal team had been able to construct a credible argument that they represented a form of undue influence. The argument was, Mireille would later observe, creative. It used the charter's extraordinary legal effectiveness as evidence against its validity, which was either the most sophisticated legal argument Fenwick had ever constructed or the most cynical, and the distinction was finer than it appeared. The third component requested the charter's immediate suspension, pending the High Court's review of the first 2 arguments. Fenwick had presented the strategy to the full court council with the professional fluency of a man who had been constructing political arguments for 3 decades and knew exactly which elements of his audience he was speaking to. He had not mentioned the court assembly. He had not needed to. Several council members who had been present and laughed were now looking at the prospect of the charter's full implementation, which would restructure their authority over Omega-designated citizens in ways they found inconvenient, and their support for Fenwick's challenge was strategic, rather than principled, and was therefore entirely reliable. Emery's received the formal challenge notification on a Tuesday morning through his council secretary, with a brief cover note from Fenwick expressing regret that this procedural matter required the council's formal attention and confidence that the High Court's review would resolve the question efficiently. He read the notification once. He read the cover note once. He set both documents in the tray designated for matters requiring response and told his secretary, "Inform Lord Fenwick that I am taking this under advisement. Inform the council secretary that no public communication is to be issued on this matter until I have reviewed it fully." Then he went to the legal library. She was at the central table. She looked up when he entered and read his face with the diagnostic precision she applied to all situations that contained information she needed to assess quickly. She said, "Fenwick." He sat across from her and placed the notification on the table between them. She read it without picking it up, leaning slightly forward, moving through it with the rapid, complete attention of someone who reads legal documents the way other people read plain language, not decoding but receiving, the meaning arriving fully formed rather than constructed word by word. When she finished, she was still for a moment. She said, "The second argument. He is using the judicial records as evidence against me." Emery said, "Yes." She said, "Those records document that judges could not rule against my writing on any prepared grounds. Fenwick is arguing that this constitutes undue influence." Emery said, "Yes." She looked at the notification for another moment. He watched her think, not the performance of thinking, but the actual process, visible in the specific quality of her stillness, the way her attention turned inward without losing its precision. She said, "The second argument contains a concession. If the court accepts that my writing has a demonstrable and irresistible ethical quality, it has accepted the core premise of the charter. Fenwick has built the cage from the bars of the gift." He looked at her. He said, "Can you use that?" She said, "I am already thinking about how to use it." He said, "I want you to know that I intend to formally oppose the challenge. That position has political costs, and I have assessed them, and I am opposing it regardless." She looked at him with the direct, careful attention of someone verifying that a statement is true rather than performed. She said, "I know." He said, "I also want you to know that opposing it will require your presence before the High Court. The same room." She was quiet. He watched her receive this and process it with the honest precision she brought to everything she needed to understand fully. She said, "I know that too." He placed his hand on the table near the notification, not touching it but present, an offer of proximity in a moment that required acknowledgement rather than solution. She looked at his hand. She looked at the notification. She reached past both of them and picked up her pen. She began to write. He came without announcement, which she had expected. She had been given guest quarters in the palace for the duration, rooms on the second level, adequate and warm, with a desk positioned near the window that caught the morning light at an angle she had immediately recognized as good for extended writing, and had arranged her materials around accordingly. She had accepted the quarters with the practical appreciation of someone who understood that proximity to the archive and the legal library was more important than the symbolic question of whether she was comfortable receiving hospitality from an institution that had recently mocked her in open court. She was at the desk when she heard his footsteps in the corridor. She knew them, had learned the specific cadence of his walk over 2 weeks of daily consultation. The way his steps were deliberate without being heavy, carrying authority without performing it. She set down her pen. She waited. He knocked once. She said, "Come in." He entered in the plain, dark clothing he wore when he was not performing the role of king. She had noticed that he had 2 distinct qualities of presence, one for the throne and its requirements, and one for the library and these rooms, and that the second was more honest and more comfortable to be in proximity to, which she had noted without yet deciding what to do with the noting. He sat in the chair across from her desk. She turned from the window to face him. The room held them in its quiet with the specific quality of a space that had been occupied by concentrated work and still carried the warmth of it. He said, "How is the document?" She said, "Almost ready." She said, "The argument Fenwick made gives me more to work with than the argument I had prepared before his challenge was filed. His concession is structural. I intend to make it do a great deal of work." He said, "I read his challenge again this evening. The third component, the suspension request. If the High Court grants it pending review, the Charter's implementation stops entirely until the case resolves." She said, "I know." He said, "The case could take months." She said, "I know that too." She said it without the particular tightness that information should have produced, which told him she had already processed it and arrived at a position about it and was not going to be destabilized by hearing it named aloud. He said, "Are you all right?" She looked at him, not the brief, deflecting glance of someone answering a courtesy question, but the real look of someone deciding whether to answer a real question honestly. She said, "I am more prepared than I was the last time I stood in a court assembly. That is the relevant variable." He said, "It is not the only relevant variable." She was quiet for a moment. He waited. She said, "Ask me what you actually want to ask." He said, "If the court goes against us tomorrow, against the charter, against your standing, what will you do?" She said, "Write better. Send it through different channels. Find the legal mechanism that works when this one fails. The charter's premises are true. True things do not stop being true because a court rules against them. They simply require more time and more patience and more precision than you initially invested, which is an argument for more writing rather than less." He looked at her for a long moment. He said, "If the court goes against us tomorrow, I will implement the charter anyway. I want you to know that before the hearing." She said, "At what cost to your position?" He said, "Whatever it costs." She assessed the statement in the way she assessed all statements that carried significant weight, not immediately, not reflexively, but with the full attention of someone who knows the difference between a thing said because it is true and a thing said because it is wanted. She determined it was true. She said, "There is something I want to tell you. About the morning of the court assembly." He became very still. Not the stillness of performance, but the stillness of someone who understands that what is coming requires them to be fully present and still. She told him. She told him what it had felt like to stand in the petitioner's position with 11 months of work in her hands and hear her words performed as comedy. She told him what she had thought during Fenwick's reading, not the anger, which had been present and which she had managed, but the specific, cold clarity that had arrived underneath the anger. The recognition that the laughter was not a mistake or an aberration, but the system expressing its actual position on the question she was asking. She told him about looking at him on the throne and what she had seen in his face in the moment before he looked away. She told it with the plain, documentary honesty of her writing voice, without accusation and without the emotional weight of a performance, simply as an accurate account of what had happened, offered because he had asked a real question, and she had decided it deserved a real answer. He received it without flinching, without reaching for justification, without any of the defensive reflexes that accurate criticism produces in people who have not yet decided to be accountable for a thing. He sat with it completely. When she finished, he said, "I looked away because I was a coward." She said, "I know." He said, "I am trying not to be." She said, "I know that too." The silence that followed was the inhabited kind, full rather than empty, carrying everything that had been said and everything that did not yet have words, and the specific quality of two people who have been honest with each other and are now existing in the same space as that honesty. He reached across the desk. His hand came to rest on the surface near her papers, not touching her, simply present, close enough to be an offer rather than a distance. She looked at his hand. She looked at his face. She did not move away. From somewhere in the palace, voices rose, two of them, rapid, and then running footsteps in the outer corridor. His senior advisor knocked and opened the door in the same motion, which was the protocol he used for things that could not wait. "Fenwick," he said, "has filed an emergency injunction. It argues that her presence in the High Court tomorrow would compromise the impartiality of the proceedings. The hearing has been moved to dawn." Emrys looked at the advisor. He looked at Mireille. She had already picked up her pen. The injunction was 22 pages long. Emrys read it in the corridor outside Mireille's rooms at the 11th bell. Standing with his senior legal advisor at his shoulder, and a torch in a bracket above them providing the specific, inadequate light of a palace corridor at night. The injunction was, as he had learned to expect from anything Fenwick produced when he had adequate preparation time, technically sophisticated, built on a careful reading of 3 separate procedural precedents and a creative application of the High Court's existing provisions regarding undue influence in legal proceedings. The core argument was this: Mireille's gift, now formally documented in the judicial records of multiple regional courts, constituted a demonstrable influence on the cognitive processes of legal decision-makers. Her physical presence in the High Court during proceedings directly concerning her own document would introduce that influence into a context where impartiality was a procedural requirement. The injunction did not describe her gift as manipulation. It described it carefully, with the technical precision of a legal document that understood it would be read by people who were themselves susceptible to the thing it was describing, and therefore framed the gift as an involuntary phenomenon rather than a deliberate act. It requested that the court exclude her from tomorrow's proceedings entirely. Emery's advisor said, "It is a strong argument." Emery said nothing. He finished reading the injunction's final page. He was aware of the closed door beside him, the room where Mireille was working, the light visible at the door's edge. The door opened. She stood in the doorway in the plain, dark dress she wore for late working hours, her pen still in her hand with the cap removed, which meant she had been mid-sentence when the sounds in the corridor had reached her. She looked at the injunction in his hands and said, "Let me see it." He handed it to her without hesitation. She took it. She read it in the corridor, standing in the doorway, with the torch light and her own door's light combining at the threshold. She read the way she always read legal documents, rapidly, completely, her face carrying the concentrated stillness of active processing rather than passive receipt. She turned pages without pause. She reached the end. She said, without looking up from the final page, "He acknowledges, formally and in a document that will enter the judicial record, that my writing has an irresistible ethical quality. That acknowledgement is the counter-argument." His advisor said, "I am not following." She looked at him with the patient directness of someone who is about to explain something to a person they believe is capable of understanding it. She said, "If the court accepts Fenwick's argument, if it rules that my gift constitutes an undue influence because legal decision-makers cannot rule against documents I have authored, then the court has formally conceded that my writing achieves a level of ethical clarity that makes opposition structurally impossible. That concession is the core premise of the Charter. Fenwick has filed a document that, if accepted, validates everything the Charter is built on. He built the argument against my presence from the same material as the argument for the Charter's validity." His advisor was quiet for a moment. Then he said, with the specific quality of someone arriving at something they should have seen sooner, "He cannot win." She said, "He can win the injunction. Excluding me from the proceedings is a separate question from validating the Charter. But winning the injunction costs him the Charter challenge, because the injunction's reasoning is incompatible with the challenge's reasoning. He cannot simultaneously argue that my writing has an irresistible ethical quality and argue that my writing is legally invalid." Emery said, "He filed both in the same week." She said, "Yes." She said it with the specific, brief quality of someone noting a strategic error that has simplified a complicated situation. She went back into her room. She sat at her desk. She picked up her pen. She did not close the door. Emery sat against the wall of the corridor, the wall beside her open door, in the light that spilled from the room. His advisor looked at him with the expression he used when the king was doing something unprecedented that he had decided not to object to, and went to find a chair. Emery sat with his back against the stone and the Charter's copy in his hands, and read it for the third time. Through the open door, he could hear the sound of Mireille writing, "The specific." rhythmic quality of a pen moving across paper with the focused consistency of someone who has entered the deep work and is not going to surface until it is done. He read. She wrote. The palace clock marked the first bell, and then the second. And the torch above him burned through its oil, and a night attendant replaced it without comment. At the fourth bell, the sound of writing stopped. She appeared in the doorway. She was holding a document of perhaps 20 pages, the ink still carrying the freshness of recent work. She looked at him against the wall, taking in the position, the charter in his hands. The empty torch bracket above, with the expression of someone updating their understanding of a situation based on new information. She said, You stayed. He said, I was thinking. She said, For 4 hours. He said, It required 4 hours. She looked at him for a moment. Something moved in her face that was not quite the not quite smile, but was adjacent to it, something warmer. She extended the document. He stood and took it. He read the first page. He looked up at her. He said, This is extraordinary. She said, Fenwick gave me the argument. I simply used it correctly. She paused. Let us go. The High Court convened at dawn with the specific, purposeful efficiency of an institution that has been doing serious things for a long time and does not require additional atmosphere to understand its own gravity. The legal hall was not the great assembly chamber. It was smaller, more concentrated. With a quality of focused attention built into its architecture, the way the assembly chamber had a quality of spectacle built into its. The ceiling was lower. The windows were narrower. The long table where the 3 judges sat was positioned with the deliberate geometry of a space, designed to make the distance between the bench and the petitioner's position feel significant without being theatrical. It was, of all the rooms in the palace's legal apparatus, the one Mireille found most honest. She had been in it once before, not as a petitioner, as an observer years ago, when she had been permitted to attend a high court session as part of a legal education program that had admitted her on the condition that she sat in the gallery and did not speak. She had sat in the gallery and had not spoken and had watched and taken notes and had understood, in the way she understood all legal environments, that what the room was designed to produce was a specific quality of accountability, the sense that what was decided here would last, would be entered into the record, would be the kind of written thing that her mother had taught her was the most powerful kind. She stood outside it now in the dawn corridor with her documents in hand. The corridor was filling, Fenwick's legal team moving past with the professional, forward-focused pace of people who had been awake early and had their preparation complete. Court officials, several council members who had arranged themselves on the appropriate side of the hall's gallery, seating with the careful positioning of people who understood that where they sat this morning would be noted and might later require explanation. A handful of Omega petition advocates who had received word of the hearing through channels Mireille had not organized but was grateful for, standing in a quiet group near the hall's side entrance. She looked at the main doors. They were the same doors, the same weight, the same wood, the same slow, deliberate inward swing of something that understood its own significance. She had walked out through these doors 6 weeks ago with her pages against her chest and the laughter muffled behind them. She had stood in the corridor outside them for 2 breaths and then begun to walk and had not stopped walking for 6 weeks. She thought about her mother's teaching certification. She thought about the regulation that had ended 14 years of exceptional service in 4 paragraphs. She thought about the ledger of dismissed Omega petitions she had found in the archive. 12 years of documents processed and filed and never acted on, each one representing someone who had done what they were supposed to do through the channels they were supposed to use and had received nothing in return except the confirmation that the channels were not designed for them. She thought about the cold cottage and the single candle and the first word of the charter going down in her clean, deliberate hand. She thought, I have been preparing for this room for a very long time. She pushed the doors open and walked through them. The hall received her entrance in the way that rooms receive things that have been anticipated, with a quality of attention that was immediate and complete. Every person present registering her arrival in the specific second of it. She walked to the petitioner's position at the center of the floor, which she reached by crossing the full length of the hall, which she crossed at the pace her body currently chose, which was not hurried. She was aware of being seen. She did not adjust herself for the seeing. Fenwick was across the floor at the respondent's table. His legal team arranged beside him with the professional composure of people who had been awake since the third bell and had decided that composure was the appropriate register for the morning. He looked at her with the expression of a man who has filed an emergency injunction and is now observing the subject of that injunction entering the room it was designed to exclude her from, and who understands that this means the injunction failed and is processing the implications of that at professional speed. She had noted, upon receiving the morning's first communication from the court, that the injunction had been denied. Dame Aldous had issued the denial herself in 3 sentences, the third of which had noted that the court would be addressing the injunction's argument in the context of the morning's full proceedings. This was the sentence Mireille had read twice, because it told her something about how Dame Aldous had understood the injunction's reasoning and what she intended to do with that understanding. She looked at the bench. Dame Aldous was a woman of approximately 70, with the specific quality of attention that develops in people who have been required, over many decades, to look at things precisely and respond to what they actually saw. She was looking at Mireille with that attention now, not warmly, not coldly, simply with the complete focus of someone who has decided that what is in front of her requires her best work and is going to give it. Beside her, the 2 associate judges held the careful, present posture of people who understood that this session was going to be different from the usual run of things. In the gallery, Emery sat in the 3rd row. He had chosen that position, not the front, where his presence would have been a visible weight on the proceedings, not the back, where it would have been an absence. The 3rd row, present as a witness, present as a person. She did not look at him directly. She felt where he was the way she felt all significant presences in a room, as information, as context, as part of the full picture of what this moment contained. She took her position. She placed her documents before her. She was entirely still. Dame Aldous opened the session with the formal, unhurried precision of someone who had been opening sessions for 40 years and had not found a reason to rush any of them. Fenwick's lead counsel rose. The argument was presented with the thorough, professional fluency of a legal team that had worked through the night and had produced the strongest version of the case available. It was a strong case. She listened to all of it. When they finished, Dame Aldous looked at Mireille. She said, "You may respond." Mireille opened the document she had written through the night. She looked at the first line. She looked up at the court. She began to read. She read the new document first. Her voice in the legal hall had the specific quality she brought to all formal readings, unhurried, clear, neither performing the emotion of the content nor draining it of its weight, simply allowing the words to exist at full volume in the room's acoustics and do what they were designed to do. The hall's architecture helped. The lower ceiling and narrower windows created a quality of concentrated sound, each sentence arriving at the bench and the gallery and the respondent's table with equal presence. No one in the room receiving less than the full text. The new document opened with Fenwick's injunction. She quoted it directly, the precise, careful language he had used to describe her gift. The technical framing of it as a demonstrable influence on legal decision-makers' cognitive processes. The formal acknowledgement embedded in his own argument that her writing achieved outcomes that existing legal frameworks could not adequately classify. She read these passages in the same voice she read everything, without emphasis, without the rhetorical shaping that would have made them sound like the weapons they were becoming. The words were sufficient. They did not require her assistance. She then presented the logical consequence. If the court accepted Fenwick's characterization of her gift, if it ruled that her writing constituted an undue influence because legal decision-makers found themselves unable to rule against it on any prepared grounds, then the court had formally determined that her writing achieved a level of ethical clarity that made opposition structurally unavailable. This determination, she said, was the core premise of the charter. Not a premise she was asserting, not a claim she was making from her own interest, but a premise that Fenwick had asserted in his own language, in a document filed with the court the previous day and now entered in the formal record. She paused. The room was very still. She said, "The respondent cannot simultaneously argue that my writing has an irresistible ethical quality sufficient to warrant my exclusion from these proceedings and argue that the charter derived from that same writing is legally invalid. These positions are structurally incompatible. The court is invited to observe that the respondent filed both arguments in the same week." In the gallery she heard nothing. She did not need to hear anything. She could feel the quality of the room's attention changing, not with the dramatic suddenness of a scene, but with the slow, progressive quality of a tide, each word adding to what the previous words had established. The argument building with the crystalline logic of something that had been assembled from honest materials in the correct order. She set the new document aside. She opened the charter. She did not read all of it. She read the provisions most directly relevant to the challenge, the sections establishing Omega legal standing, the enforcement mechanisms, the protections against institutional dismissal without appeal. She read them in the plain, deliberate voice of someone reading something they wrote because they believed it to be true, each sentence placed with the care of a builder who understands that the integrity of the structure depends on every component being in its correct position. The gift activated. She felt it the way she always felt it when the conditions were fully met, the specific warmth of crystallization occurring, the text achieving the completeness that made its ethical truth not persuasive but demonstrable. She did not change her voice. She did not slow down or speed up. She simply continued reading, and the room continued changing around her, the quality of its attention deepening past the professional into something more fundamental. Fenwick's lead counsel had been taking notes. The pen stopped. She observed this in her peripheral vision without redirecting her gaze from the document. The pen had stopped at the third provision's second paragraph, and it did not resume. Fenwick himself sat at his table with his hands flat on the surface, and his face carrying the expression of a man who has encountered a cognitive destination he cannot reach. Not because the path is blocked, but because the path, when examined, leads somewhere other than where he intended to go. He was still. He was not performing stillness. He was simply unable to move through the argument he had been holding in the direction he had been holding it. She finished. She set the charter down. She placed her hands at her sides. She waited. The room was quiet with a quality that was different from the ordinary quiet of a legal proceeding awaiting a ruling. It was the quiet of a space in which something has been fully understood, in which the question has been answered so completely that the usual deliberative machinery has nothing left to deliberate. Dame Aldous looked at her two colleagues. The exchange was brief, two of the most experienced legal minds in the kingdom looking at each other across the bench with the specific expression of people confirming something they already knew. Dame Aldous looked at Fenwick. His lead counsel had set down his pen and had not picked it up again. Fenwick looked back at her with the professional composure of a man who had not yet publicly accepted the outcome and was not going to make it easier for the room by doing so prematurely. Dame Aldous said, "The court will take a brief recess to review its position." She rose. The room rose. In the gallery, Emery stood. He was not looking at the bench. He was not looking at Fenwick. He was looking at her across the full length of the legal hall. And what she read in his expression had no legal category and required no precedent and was not going to be entered into any formal record. She held his gaze. The room moved around them, people rising, the shuffle of a hall in recess. The murmur of voices finding their private registers again. She and Emery's were still at the center of it, looking at each other across the distance. And what passed between them in that look was the specific, irreversible acknowledgement of two people who have been through something significant together and know, in the same moment, that they are on the other side of it. Dame Aldous returned from recess in 14 minutes. This was noted. High court recesses in cases of this complexity typically ran between 1 and 3 hours, the time required for the bench to review positions, consult precedents, draft the ruling's formal language, and arrive at a stated consensus that would withstand subsequent legal scrutiny. 14 minutes meant one of two things. Either the ruling was so straightforward that it required no deliberation, or the bench had entered the recess already in agreement and had used the time only to draft language adequate to what they had understood. Both were true. Dame Aldous delivered the ruling in the precise, formal register of the High Court's tradition, a voice that had been trained over 40 years to carry the specific weight of things that were going to be written down and would last. She ruled on the injunction first, denied, on the grounds that excluding a party from proceedings concerning their own document on the basis of that document's quality was procedurally incompatible with the court's foundational commitment to access. She noted, in language that was formal but unmistakably pointed, that the injunction's argument had conceded more than it had challenged. She ruled on the charter's validity second, valid, on every contested ground. The ruling addressed each of Fenwick's three components directly: the registration argument, the undue influence argument, the suspension request, and dismissed each with the methodical thoroughness of a court that had done its reading and was not going to be moved by arguments it had already examined and found insufficient. And then she did something unprecedented. The ruling's final section contained a formal written acknowledgement, 4 paragraphs, entered into the High Court's permanent record, stating that the charter represented a legal document of exceptional ethical quality, that the court's ruling reflected not merely legal validity but moral necessity, and that the court considered the document's unusual effect on judicial decision-making to be evidence of the quality of its reasoning rather than evidence against the legitimacy of its author. The 4 paragraphs named Mireille as the author with her full designation and her full name and no qualifying language of any kind. Fenwick received the ruling with the professional composure of a man who had expected this outcome for approximately 14 minutes and had used those minutes to compose himself into something that looked like equanimity. It was a competent performance. The room was not entirely convinced. The full court assembly had been convened for the formal announcement, summoned by Emery's before the High Court session began, which had told the court officials who received the summons something about what the king expected the morning's outcome to be, and which had produced, in the assembly chamber, a gathering that included every person who had been present 6 weeks ago when a woman's words were read in an exaggerated voice while the assembly laughed. They were not laughing now. Emery's addressed them from the throne, not the position of a king making a policy announcement, not the formal, measured register of institutional correction, but the register he had been developing over 6 weeks of sustained honesty, the register of a man saying what was true rather than what was manageable. He said, "I am going to speak about what happened in this room 6 weeks ago, not about what should have happened procedurally, not about what institutional mechanisms failed. I will address those. But I am going to address this first, because it is the more important thing." He named what had happened. He named it with the specificity that made it real rather than abstract. Fenwick rising, the exaggerated voice, the laughter, his own throne and his own face, and the decision he had made in the moment he looked at her and looked away. He said, "I made a calculation. I assessed the political cost of taking her work seriously in a room that had decided not to. And I determined that the cost was higher than the cost of allowing what was happening to continue." He said, "That calculation was wrong. Not wrong in its outcome, although its outcome was also wrong. Wrong in its structure. I treated a question of fundamental respect as a question of political expenditure. Those are not the same category, and I used them as if they were. The room was quiet. Not the quiet of approval, the more significant quiet of an assembly confronting something accurate about itself and being given no comfortable place to put it. He named what the charter was and what it had done and what it had cost its author to produce. In the specific, evidence language of a man who had spent 2 weeks learning it. He did not editorialize. He named the facts and let the assembly understand what the facts meant, which was more effective and more honest than telling them what to feel about it. He announced the charter's full implementation, not as a legal concession or a political gesture, but as the thing that should have happened when a woman carried 11 months of careful work through the official channels and presented it correctly, and the official channels failed her. He named the implementation timeline, the independent review mechanism, the enforcement structure. He named, specifically, the retroactive assessment clause for Omega educators dismissed under the certification regulation, and he named it in a way that left no interpretive ambiguity about why it was there and whose history it was designed to address. Fenwick submitted a procedural objection. It was his right. It was entered into the record. Emery's acknowledged it, noted it, and overruled it in 2 sentences with the flat, complete certainty of a man who has made a decision from the right premises and is not going to be moved from it by procedural friction. He turned to where Mireille stood in the petitioner's position, the same floor, the same room that had laughed at her words 6 weeks ago. He said, in the full hearing of everyone present, I am appointing you as the kingdom's first Omega legal counsel. The position carries full standing in all court proceedings and full authority over the implementation of the Omega Charter. It is established by royal decree and carries a salary commensurate with the position's authority. It cannot be rescinded by council vote. He said, this appointment is not sufficient to address what this court did 6 weeks ago. It is the correct next thing. The assembly received this in a silence that was different in every possible way from the silence of 6 weeks ago. It was the silence of an institution confronting the full documented, publicly stated consequence of what it had permitted, and understanding that what came next was going to be different, and that the difference was not optional. Mireille stood in the petitioner's position and felt the room's attention land on her completely. Not the laughter, not the dismissal, not the lazy assessment of something not worth looking at directly, but the full, irreversible acknowledgement of a room that had been required to look and had looked and could not now claim it had not seen. She received it with the stillness she had learned to trust, not the stillness of someone absorbing a blow, but the stillness of someone who is entirely present and does not require the moment to be other than it is. The assembly did not laugh. The implementation began on a Monday. Mireille had spent the week between the High Court ruling and the first formal implementation session, doing what she always did with the interval between a decision and its execution, using it to prepare with the thoroughness of someone who understood that the gap between a law being passed and a law being real was where most of the important work lived, and that most of that work was invisible, and that its invisibility was not an argument against doing it, but an argument for doing it more carefully. She had prepared the implementation sequence in the same way she had prepared the charter, completely from the foundation, with every component's relationship to every other component mapped before the first session began. The sequence had 7 phases. Each phase had specific legal mechanisms, specific timelines, specific verification requirements. She had built the verification requirements into the sequence itself, rather than appending them afterward, because she had spent 11 months in an archive full of laws whose verification requirements had been insufficient, and she was not going to produce another one. The first formal implementation session convened in the working council chamber, the room with adequate light and the table that seated 12 and the window onto the inner courtyard. which she had chosen over the formal deliberation chamber, for the same reason she had chosen the legal library for the consultation with Emery's. Because the work was more important than the room's impression of the work. She chaired it with the same quality she brought to every formal process she led, methodical, precise, entirely without the performance of authority, because she had found, over the years, that performed authority was a signal that actual authority was uncertain, and her authority in this room was not uncertain. The first phase addressed formal legal standing. Every Omega-designated citizen gained formal petitioner standing in all court proceedings, the right to submit documents, present arguments, file appeals, and receive the same procedural treatment that other designations had always received as a baseline assumption. This provision required the explicit amendment of 17 existing procedural rules and the creation of 4 new ones. She had drafted all 21 amendments before the first session. The council reviewed them. 2 members proposed modifications. She considered both modifications with genuine attention, not the performed consideration of someone who has already decided, but the real consideration of someone who understands that other people sometimes see things she has not seen. One modification improved the document. She incorporated it. One modification would have weakened an enforcement mechanism in a way that appeared technical and was actually structural. She explained why, with the evidence, without heat. The modification was withdrawn. The second phase addressed the employment appeal mechanism, the formal right of appeal for all Omega administrative decisions, including employment decisions of the kind that had ended her mother's teaching career. The retroactive assessment clause required, in its implementation, a formal review board with independent membership and defined timelines, and a documented decision process that produced written rulings subject to further appeal. She had modeled it on the strongest existing appeal mechanisms in the kingdom's legal record, incorporating the elements that made those mechanisms durable and removing the elements that made them exploitable. The educational certification component came before the board in the 3rd week. She had known it would arrive in the 3rd week because she had designed the sequence with that timing deliberately, placing it after 2 weeks of successful implementation precedent. After the review board had established its processes and demonstrated their function. After the council had seen enough of the mechanism working to understand that what was being asked of it in the certification case was consistent with what it had already committed to rather than an expansion of that commitment. Her mother's case was not the first one reviewed. She had not put it first. She had placed it in the sequence with the same care she placed every component, in the position where its resolution would be most durable and least susceptible to the procedural challenges that early, high-profile cases sometimes attracted. She had not told her mother about the clause until the implementation sequence was already underway and the review board was already constituted and the process was already functioning. Because she had learned from 11 months of legal work that telling someone a thing was possible before the infrastructure to make it possible was in place was a form of cruelty dressed as hope. She told her mother the week before the case came before the board. She traveled to her mother's home in the Mid-Territory, the first time she had made that journey since leaving for the capital 11 months ago, and sat across the kitchen table from her and explained what the retroactive assessment clause was, what the review process would look like, what the possible outcomes were, and what the timeline was. Her mother listened with the complete, precise attention she had always given to things that required it. When Mireille finished, she was quiet for a moment. She looked at the table. She said, "The words that hurt you most are always the ones written down." Mireille said, "Yes." Her mother said, "You wrote better words." Mireille said, "I tried." Her mother looked at her with the specific, complicated expression of a parent looking at an adult child who has done something significant that is connected, in ways that are not simple to articulate, to a harm they suffered and a lesson they taught. She said, "You always did, even at 11. The board ruled in her mother's favor 6 days later. The certification office was directed to process her application under the amended regulations within 30 days. The ruling was entered into the formal record. It was a written thing. It would last. Fenwick submitted 3 procedural challenges during the implementation period. The first challenged the composition of the review board on the grounds that its Omega membership exceeded the proportion established by existing administrative precedent. She addressed it in writing, in a document of 4 pages that dismantled the argument with the efficient precision of someone who had anticipated it specifically and had the precedent to hand. The challenge was dismissed. The second challenged the timeline requirements as impractical. She addressed it in a document of 3 pages that presented the implementation data from the first 2 phases demonstrating that the timelines were being met without exception. The challenge was dismissed. The third was a more creative attempt, a procedural argument about the sequencing of the 7th phase that was technically sophisticated and structurally identical to an argument that had failed. In a different context in the Eastern Territories 17 years prior, she cited the Eastern precedent in 2 sentences. The challenge was dismissed. Through the implementation period, Emery's attended the sessions she invited him to and was absent from the ones she did not, which was the appropriate distribution and which he had understood without being told. In the evenings after long sessions, they had developed the library habit, the walk through the long corridor of archived law, the old paper and the amber light, and the accumulated written record of everything the kingdom had decided was true. She told him what she was building. He told her where the resistance would come from and in what form. She adjusted. He adjusted. It was the most useful professional relationship she had ever had, which she had told him once directly, and which he had received with the specific quality of someone who understood that he was being given information rather than a compliment and who valued the distinction. She was in the council chamber alone on the evening the 7th phase's final provision was entered into the formal record, the last of the Charter's first implementation cycle. The provision requiring the Royal Legal Office to establish and maintain a formal registry of all documents containing Omega welfare provisions with an independent review mechanism to monitor against quiet repeal. The chamber was empty. The candles had been burning for 3 hours. The provision was written, signed, stamped, and entered. She looked at it. She looked at her name on it. She looked at the document number, which was now part of the formal legal record and would be cited in future cases and reviewed in future challenges and would require defending by people who were not yet in this chamber but would come after her. She thought about her mother at the kitchen table. She thought about 4 paragraphs and 14 years of exceptional reviews and the word that her mother had used, written, and the way she had understood it differently than it was intended, as a direction rather than a grief. She put down her pen. She folded her hands on the table. She sat in the quiet of an empty council chamber with the last provision of the Omega Charter's first implementation cycle in front of her, and she allowed herself, privately, to feel the full weight of what the ink had made permanent. 2 years after the High Court, the Omega Legal Institute enrolled its first class on a Wednesday morning in early spring. Mireille knew the enrollment number because she had been tracking it since the application period opened, not with anxiety but with a specific, steady attention she brought to everything she considered important enough to monitor accurately. 42 students. She had projected between 30 and 50 based on the kingdom's documented population of Omega-designated citizens with legal education backgrounds or demonstrated legal aptitude. 42 was within the range and slightly above the midpoint, which she considered satisfactory. The Institute occupied a wing of the palace's eastern building, the same wing that housed the legal library, which had not been accidental. She had specified the location in the founding documents with the plain, direct reasoning she used for all significant decisions. The library was the resource the Institute's students most needed. Proximity to it was therefore the most important spatial consideration. and the eastern wing had available space and adequate light, and a courtyard that received the morning sun at an angle she had assessed as beneficial to the quality of thought that extended work required. The palace's administrative office had flagged the location request as unusual. She had sent a 4-page document explaining the reasoning. The request had been approved. The building had been redesigned under her specification, not to look prestigious, not to announce itself to the city around it as an institution of significance, but to function as a place where serious work could be done by people who had never previously been given a space designed for their serious work. The rooms were sized for working groups of 8 to 12. The individual study spaces had adequate light and adequate quiet. The archive annex connecting the institute to the main legal library had been Wren's design. Wren, who was now the institute's head archivist, a position created in the founding documents specifically, with a salary that reflected 38 years of institutional knowledge and a formal title that reflected what she had actually been doing without recognition for most of them. Wren had accepted the position with the specific, quiet satisfaction of someone who has been offered recognition that is accurate rather than generous, not more than she deserved, simply finally equivalent to it. The 42 students came from across the kingdom. Several of them Mireille knew, young Omegas she had encountered during the charter's implementation. People who had been doing the legal work that the system had not made room for, and who had been doing it without the institutional support the institute was designed to provide. Others she did not know. She had reviewed every application herself, which her administrative coordinator had flagged as an unusual use of the Omega Legal Council's time. She had explained once that she intended to know what each student was bringing to the institute before they arrived, and had not explained further, because she had found over 2 years that explanations beyond one were rarely necessary if the first was accurate. She stood at the institute's main window on that Wednesday morning and watched the 42 students move through the courtyard below. They were carrying legal texts, the institute's standard first-year materials, which she had selected and in several cases written. The curriculum built from the same foundation as everything else she had built. The honest assessment of what the work required and the construction of the most direct path to providing it. They looked uncertain in the way of people who have arrived somewhere they were told they belonged, and are in the process of discovering what believing that actually feels like from the inside. She recognized it. She had felt it herself, in different rooms, at different ages, always with the same quality, the specific, provisional nature of a belonging that has been offered, but not yet fully inhabited. She thought about what they were going to learn. The law, in its technical architecture, the precedents and procedures and the formal structures that determined how rights were established, challenged, and defended. And the other thing, which was less teachable, but which she had built into the curriculum in every way she knew how. The understanding that the law was not a fixed object, but a living document, responsive to the quality of argument brought to bear on it, capable of being made more just by people who were willing to do the careful, patient, invisible work of writing it better. She had written it better. She intended them to do the same. The Equal Legal Council had been meeting monthly for 18 months. 6 Alpha representatives, 6 Omega representatives, full voting standing for all. The record of their decisions as binding as any prior court ruling. Corvin had retired from his council seat 3 months prior and been replaced by a young Omega advocate from the Northern Territory who had submitted the most technically rigorous application Mireille had reviewed. The council had agreed. The young advocate had been present for 4 sessions and had already identified a procedural gap in the Charter's third provision that Mireille had not seen, and had written a proposed amendment that she was going to bring to the next session. She was looking forward to it. Wren appeared at the Institute's upper corridor with the morning's administrative correspondence, a stack of moderate size, which was a good morning by current standards. She looked at Mireille at the window and at the courtyard below and produced the small, satisfied sound she made when something she had helped make possible was operating as intended. Mireille said, "The third-year seminar rooms need better light on the western side." Ren said, "I submitted the request to the Palace Facilities Office last week." Mireille said, "And?" Ren said, "They said 2 weeks." Mireille said, "I will write them a letter." Ren said, with the dry, affectionate certainty of someone who has known a person for long enough to understand exactly what a statement like that means, "I will tell them to expect it." She left Mireille to the window and the courtyard and the morning. Footsteps in the corridor, the ones she knew before she heard them. The ones that had become as familiar as the sound of the archive's particular quality of silence, or the specific creak of the legal library's third shelf from the left on the eastern wall. The small landmarks of a life that had found its shape around certain constants. Emery's appeared in the doorway, not in court dress. The plain, dark clothing of a man who had been coming to the Institute on Wednesday mornings for 6 months, and had settled into a version of himself in this building that was different from the version the throne required. Less formal, more present. The version she had first encountered in the corridor outside her rooms the night before the High Court. He looked at the courtyard. He came to stand beside her. They looked at the 42 students together, moving through the morning sun below with their legal texts and their provisional, developing belonging. He said, after a moment, "They look like they mean it." She said, "They do." He was quiet for a beat. Then, "So did you?" "The first day I read it. Before I understood what I was reading. There was something in the first page that I could not dismiss, even before the gift activated. I did not know what I was encountering, but I could not dismiss it." She said, "You initialed a report that described my gift as Category 3 minor palliative." He said, "I did." She said, "I forgave you for that." He said, "When?" She said, "When you sat in a corridor all night reading my charter by torchlight and did not tell anyone you had done it." He looked at her. She looked back at him with the full, unsparing attention she gave to things she had decided were worth seeing completely. The morning light was doing what it did in this room at this hour, arriving at the angle she had specified in the building's design. The angle she had assessed as beneficial to the quality of thought that extended work required, and landing on everything in the room and making it visible. He reached for her hand. She gave it, not the careful, provisional gesture of the earlier months, but the complete one. The gesture of someone who has decided that this is real and has been real for some time, and who has stopped finding reasons to treat it as anything other than what it is. Below, in the courtyard, 42 students were opening their legal texts. The law that had been written by a woman who was laughed out of a court and refused to stay gone was in their hands. They were learning its architecture, its history, its gaps, and the specific, irreplaceable skill of writing it better. The skill she had been practicing since she was 11 years old at a kitchen table. Understanding, for the first time, what words written down could do. The morning light held everything it touched. Her story has come to an end, but our journey together continues. If you found this story inspiring and meaningful, please like the video to support me. Don't forget to subscribe to the channel and turn on notifications so you don't miss the next empowering stories. And if you have any thoughts about the characters, her journey, or want to share your own story, please comment below. I really look forward to reading and chatting with you.